Thank you, Mr. Chair and members of the
Thank you.
committee. Ian Hewitt, I'm General Counsel at Cornerstone, which is a Christian advocacy organization. I wanted to make myself available to answer any questions about how this bill relates to state and federal non-discrimination laws, and I hope to and look forward to answering some tough questions about that. But in my testimony, I wanted to focus on how clarifying the debate around this bill is. Because oftentimes in this area, you will hear people on the other side of this issue say something like, for example, the state can differentiate between men and women, it just can't differentiate between transgender women and non-transgender women. Now, that kind of statement can be confusing and disorienting if you're not initiated into the kind of well-constructed system of jargon that cultural progressivism has created around issues of gender. And it can be unclear at first glance whether people in that group see any role at all for biology. But the debate around this bill very clearly illuminates that issue. Representative Gould's bill is so modest that it would not even exclude a single biologically male athlete from competing in women's sports in New Hampshire. It simply says the state can recognize biological males and females as real groups of people and can differentiate between people on that basis, which has always been part of federal constitutional law in this country and internal agency policies in New Hampshire. And yet, we have heard from NAMI and from GLAD that by itself is invidious discrimination and is illegal somehow. And you don't need to be a lawyer or a constitutional scholar or a philosophy professor to tell that if the state can't even say it reserves the right to consider biological sex, then the state can never differentiate between people on the basis of biological sex. And if we go one premise deeper, I assume my opponents here don't think they're telling you to ignore reality. So it follows just biological necessity that opponents of this bill don't even think biological males and females are real groups of people. And in fact, we can hear that in terms like sex assigned at birth, the idea being that the two sexes, which are 1.2 billion years old, are purely imaginary, arbitrary social constructs assigned to you by society. And this should raise alarming questions not just for whether some biological males can compete in women's sports, but whether we can even in the first place have separate sports leagues and prison facilities and so on for these two apparently imaginary, purely socially constructed groups of people. And I would love to take any questions, legal or otherwise.
Questions for Mr. Hewitt? Representative.
Thank you,
Kelsey.
Mr. Chairman, and thank you for taking my question. I just want to follow up on Representative Gay's question. Would you explain the distinctions between the three elements of the law?
Yes, I would like to speak to what Representative Gay said, and I think that what Representative Gay brings up is important and raises an important opportunity for clarification. Because, as I said earlier, this bill does not compel any school board or any entity to adopt any particular policy. It reserves the right of state agencies and the state to differentiate based upon biological sex. So it would not automatically exclude anyone from anything. Now, in the area of incarceration, and I believe it was Representative Cannon raised an interesting hypothetical about, well, what about someone who's taken hormonal medication, they've had gender reassignment surgery, do we really want to incarcerate that person in a men's prison? It's actually already the policy of the New Hampshire Department of Corrections that they will consider on a case-by-case basis, in such cases, which facility to assign that person to. Now this, to my knowledge, hasn't actually come up yet, but they would make a case-by-case consideration in that instance, and I think that's the right policy. However, that presumes that the state can take into consideration biological sex and can differentiate on that basis. In California, for example, California's prison policy is even someone who has had no hormonal treatment, who has had no gender reassignment surgery, in other words, someone who looks like me. If they consistently assert that they are female in California, that person will be transferred to a women's prison because in California, it's based on gender, self-declared gender identity, period. So even our status quo in New Hampshire, where we can make case-by-case considerations, and that is appropriate, that requires that the state retain the ability to consider biological sex and treat these as real groups of people, not purely fictitious social groups.
Okay. Thank you, Representative Cannon.
Thank you, Mr. Chair. Thank you for taking my question. You've indicated that the state prison system already has a procedure in place to identify a transgender person where it might be appropriate to incarcerate them. Why do we need a statute to do that?
Well, the statute doesn't determine where anyone is incarcerated. The statute says that the state can recognize biological males and females as real groups of people and can differentiate based on that basis. The New Hampshire Department of Corrections policy, just so I'm absolutely clear, it doesn't say you assign people based on your gender identity in New Hampshire. What they do say is that in cases like that, the New Hampshire Department of Corrections will consider all the factors, including the safety of the inmate, the safety of other inmates, and they make a case-by-case determination, unlike in California where it's automatic based on consistently self-declared gender identity. And if I could give one specific example of why this is important.
If you'd hold on that, because we have many more people to testify, and we're over time right now, and I apologize, but was there a follow-up, Rep. Cannon?
Yes.
Just if you focus on the follow-up,
quick.
but we do
Yes.
need to move forward.
Yes. So you said that still is, there's a procedure already in place that's actually fairly extensive. So why is this statute, a law, required since it's already done here in New Hampshire?
Well, I think the example I was about to give is actually responsive to that question, Mr. Chair. And the example I was going to point to was there is an 11th Circuit Court of Appeals decision about a Florida case where this was a case about bathrooms. It wasn't about prison, but the same reasoning applies, where the school district said, well, we want to differentiate based upon biological sex. And the 11th Circuit Court of Appeals in that case said, they ruled against the school board, and they said to the school board, biological sex, the 11th Circuit Court of Appeals said, they said, what are you even talking about? This transgender boy, in this case, the 11th Circuit said, his driver's license from the state of Florida says that he's a male, and his birth certificate says that he's a male. And according to the 11th Circuit Court of Appeals, gender identity simply is what the state says it is. The law does not recognize any other biological sex, quote unquote. So if we were to adopt this bill, the answer to your question is that the New Hampshire Department of Corrections would retain the ability to make case-by-case determinations and could consider factors like the factors you raised, hormonal treatment, surgical treatment, and consider biological sex also, as opposed to automatic assignment based on what the state says, like in the 11th Circuit, or based on consistently self-declared gender identity, like in California.
All right, thank you. Representative Kofalt.
Thank you, Mr. Chairman, and thank you, Attorney Hewitt, for taking my question. So we've heard the word discrimination used on a number of occasions here in testimony. And at the federal level, discrimination is defined under Title VII. So there was a landmark case several years ago heard by the Supreme Court, Bostock versus Clayton County. And I assume you're familiar with that.
Yes.
So I'm trying to understand sort of from the viewpoint of that case, which essentially said that the prohibition on discrimination based on sex extends to transgender people and different sexual orientations. How might the Bostock case be applied if this were to become law in New Hampshire?
I think that's a great question. I think that the Bostock interpretation of Title VII can be very helpful as we think about this bill, and I could explain that in a couple of minutes or less, I hope, with your leave, Mr. Chair.
Not here, not today.
Okay.
But in terms, so there'll be a further discussion on this, but we need to hear from everyone because we have other scheduled meetings.
Well, I'll do my best to give a few sentences, I suppose.
If you would, please.
My few sentence answer would be, Bostock explained, when a law prohibits discrimination because of a certain factor, we change that factor and see if we get a different result in the scenario. So if you fire, in New Hampshire, for example, we have a state statute prohibiting discrimination on the basis of gender identity. So if a male employee comes into work and says that he identifies as a woman, and you fire him, to determine if there was gender identity discrimination, we change the gender identity. So suppose the biologically male employee comes into work and identifies as a woman. Would you have, as a man, that identifies as a man, we're going to change the gender identity. Would you fire him? Presumably no, so there was gender identity discrimination. Now the distinction and the way this is particularly helpful is, suppose a biologically male athlete wants to compete in women's sports, identifies as a woman, and is denied. To determine if there's gender identity discrimination under Bostock, what do? We switch the gender identity. So instead, we imagine a biologically male athlete identifies as a male and wants to compete in women's sports. Would the result be different? No, the result would be the same. He would still be denied. So what has happened there is not gender identity discrimination like in Bostock. What's happened there is sex discrimination, and sex differentiation is allowed under limited circumstances under long-standing constitutional law.
Thank you very much. We'll recognize Representative Weber.
Thank you, and thank you for taking my question. You've stated repeatedly that this doesn't mandate anything. It permits somebody from taking natal sex, whatever we're calling it, into account when making a determination. My question is, where is the protection when somebody arbitrarily says, the only consideration we will ever consider is the sex you were born with rather than anything that has transpired since? What is the protection for transgender people under that scheme?
Well, for example, in the hypothetical I just gave, which would be under 354A, which is our state non-discrimination law, clearly if you fired a biologically male employee for identifying as a woman, that would be a violation of our state law, and there isn't anything in this law that would change that. So we do have state non-discrimination protections for transgender people, and those would remain in place.
Thank you very much, Mr. Hewitt. And no further questions. Thank you for your testimony.
Thank you.